Good morning, everybody, and thank you for joining us this morning for our latest webinar, which we again have the pleasure of hosting in partnership with Michael Page. For those of you on the call who don't know me, I'm Helen Cage and I'm a partner here at Irwin Mitchell, specialising in employment law. And I'm joined today by my colleague Mandeep Crude, who specialises in immigration law and heads up our immigration team here at Irwin Mitchell. Next slide, please, Jessica. So our contact details are there on the screen together with our QR codes, which you can scan to connect with us on LinkedIn. Now, LinkedIn's where we share the majority of our legal updates, so please do connect with us if you can, and that way that we can keep you updated on all employment law changes and immigration changes as and when we know them. Mandeep will be leading the webinar for us this morning, and what she'll be explaining to us is the process for employing foreign nationals now that we've left the EU, which involves applying for a sponsor licence, and she'll also be explaining the benefits that holding a sponsor licence could have for your business, especially if, like many UK companies, your business is suffering from a shortage of skilled labour, or you're just generally struggling to recruit and retain key skilled staff. Now there'll be time at the end for questions and answers, so please do add your questions to the Q&A box during the session today, and we'll pick up those questions at the end. We've also received some pre-submitted questions, thank you very much. So again, we'll pick these up at the end as well. And there's also a feedback form, and it'd be great if you can complete that. Now, Jessica will add the link to the feedback form at different points during the session this morning. I think she's already done so. So if there's any questions that you think of at the end that you haven't had time to ask, or if there's any materials that we could provide you with, or if there's any further advice that you need in connection with immigration or employment law, then please just note that down on your feedback form. And when Mandeep and myself are doing our follow-up, we'll make sure that we pick these up with you. So without further ado, I'll hand over to Mandeep.
Thank you, Helen. Hi, everyone. Sorry, can I next slide, please? So what I'm going to be talking about today is what is a sponsorship license and how do you apply for one? And then we'll go on to who is eligible for the working type visas and explain what a certificate of sponsorship is. We'll then go through what the visa application process is and what the fees associated with the visa applications are. And then we'll do a quick recap in terms of the above, and then we'll go on to what the right to work checks involved when employing anybody in the organisation. Could I get the next slide, please? So the first section is the sponsorship licence and how do you apply for a sponsorship licence. Next slide. Okay. So as an overview, all non-British and non-Irish workers now need to be sponsored to work in the UK. If they are currently in the UK, for example, with pre-settled status or settled status, or students, or people who are currently in the UK on a spouse visa, so they're either married to a British national or previously a European national, they don't need to be sponsored because they already have the automatic right to work for any organisation. Now, if it is somebody that you require who is a foreign national and you want them to come and work for your organisation, the only way in which you can now do that, even if they are European nationals, is via a sponsorship licence. So initially, the company will need to apply for that. The Home Office are very clear that with a sponsorship licence, it's a privilege and not a right if you have one. And that means that sponsors must play their part in ensuring the immigration system is not abused at all. And if it is abused, then there are fines that are imposed on the sponsor. So between July 2022 and September 22, there was over £1.7 million worth of fines issued to businesses in the UK. And out of that, the largest fine for a business was £60,000 and the smallest was £10,000. So it's important that if you are applying for a sponsorship licence, that you make sure that you are compliant with the duties and responsibilities to prevent any fines or revocations or suspensions of a sponsorship licence. Could I get the next slide, please? Thank you. So in terms of the application steps in applying for a sponsorship licence, you first need to decide the routes your company wants to be licensed under, and then you also need to look at what kind of key personnel are going to be part of the whole sponsorship license process. Then you also need to look at the kind of documentation that needs to be attached to the application for the sponsorship license. And once you've got all of that, you would then complete the online form and pay the relevant government fees. And then once the online form has been submitted, you then need to send the documents to the Home Office by email within 5 working days. After that, normally a decision using the standard process is 8 weeks, or it can be sooner if you use a priority service, and it's normally within 10 working days. What we'll do is we'll go now through each of these points in a bit more detail on the next slide, please. So initially I mentioned that you need to decide on what visa routes that you want to apply under. The normal or the most common one is the skilled worker route, and that allows anybody who's a foreign national to come and work for a company as long as they meet the relevant job titles, and they will be paid the relevant salary in the UK. With people who come into the UK or switch to a skilled worker visa, they are entitled, after being on a skilled worker for 5 years, they're entitled to permanent stay in the UK, which is called indefinite leave to remain. One of the major requirements or difference between the skilled worker visa and the global business mobility visa for senior specialist workers is that there is an English language requirement that needs to be taken to meet the requirements for the skilled worker visa, and you need to be able to speak, listen, understand and write English to level B1 of the Common European Framework. In terms of the global mobility senior or specialist worker type visa, this is for when organisations have overseas businesses and UK entities and they want to bring their employees from overseas to the UK. Now, normally the employee or prospective employee will need to have been working for the overseas company for at least 12 months, and they'd need to be paid a salary of £42,400 in order to come under this category. Now, if the prospective employee hasn't been working for 12 months or more in the overseas company, they can still come to the UK if their salary is going to be £73,900 per annum. Now, with this category, it doesn't lead to indefinite leave to remain, but you can stay for 5 years in the UK on this, and then you'd have to return back. Or if your salary is at 73,900 plus, then you can extend that visa for up to 9 years if you wish. There's also the Minister of Religion type visa, and there's also the International Sports Person visa. Excuse me, and with the International Sports Person visa, that's available for elite sports people or qualified coaches who have an offer from, an organisation to play whatever sport it is in their particular field in the UK. But the applicant's job would need to be endorsed by the sports governing body. So, for example, for a football club, the governing body is the FA, and so the individual sports person who wants to come, for example, to play for a football club would need to obtain a letter from the FA to say that the applicant is internationally established at the highest level and that the applicant will make contributions to the development of the sport at the highest level in the UK. There's also temporary sponsorship licence categories such as charity workers, creative workers, government authorised exchange, the global mobility routes for graduates and expansion workers, and there's also religious workers and seasonal workers, but they're all temporary type sponsor licence categories. Could I get the next slide, please? In terms of the key personnel that I'd mentioned earlier, when you're applying for a sponsorship license, you must have an authorising officer, a key contact, and a level 1 and level 2 user. The authorising officer is somebody who is senior within the organisation, normally senior in the HR or recruitment area. And the authorising officer is the person that, if the Home Office come and audit the organisation, it would be the authorising officer that they would need to see. You also have the key contact, who is the main contact between the Home Office and the company, and that can be a legal representative if need be. So if the Home Office have particular questions in terms of the sponsorship licence that they want answered, it would be the key contact they would contact in terms of that. The level 1 and level 2 users, they are the people who have the normal day-to-day responsibilities of applying for certificates of sponsorship and assigning them to the relevant migrant worker. So you would have a daily use of the sponsorship licence, depending on how many certificates you're going to be issuing or assigning to people. As a level 1 user or a key contact or an authorising officer, they must normally be based in the UK for the period that they will be the key personnel. They can't have any unspent criminal convictions, and they must be a paid member of staff. And as long as they meet that criteria, they can be the key personnel. What we have found in the past is the sponsorship licence, once it's granted, is granted for 4 years. And during that period, level 1 users and authorising officers do end up leaving companies or organisations, but the new authorising officer or level 1 user has not been inputted onto the sponsor management system. And this can cause major issues, because if the authorising officer has left and no new authorising officer has been put on, when you get the update in terms of, you need to renew your sponsorship licence, it's the authorising officer that gets that notification. And if they're not there, then you don't get that notification. And hence, sometimes sponsorship licences have lapsed. And that would mean that anybody who is sponsored on that sponsorship licence is actually an illegal immigrant. And that can have a major effect on them, the actual employee, wanting to get potentially indefinite leave to remain. Or if, while they are in the UK legally, they left the country and tried to come back into the UK, they may not be able to, and that could affect, again, their indefinite leave to remain application. So there could be quite a lot of issues in terms of that, and we have dealt with those, and we have managed to resolve the issue without it causing too much of a problem for the company and for the individuals. Could I get the next slide, please? So once we've worked out which categories we want to apply for the sponsorship licence under, and we know who the key personnel is, then we need to start collating all the documents to support the sponsorship licence application. And in general, the type of documents that you need to have in place is proof of registration with HMRC, tax returns, financial reports, employer's liability insurance, proof of ownership or lease of the business premises, and corporate bank statements. If you're applying to link overseas companies to the UK one, you would need an affidavit to support that, as well as agreements and articles of association. And if you're applying for the skilled worker visa, then you would need to explain in the cover letter that why you're applying for the sponsorship licence, what job role that person is going to be filling, and what sector they operate in, and details about their hours of work. In terms of how long they're going to be working, is it going to be 9 to 5 or is it part-time, etc. Could I get the next slide, please? Thank you. In terms of the sponsorship licence and the government costs associated with it, if the business is classed as a small or charitable sponsor, then the government fees is £536. If the company is classed as a medium or large sponsor, it'd be £1,476. A company is classed as a small sponsor if at least 2 of the following apply. So if the annual turnover is less than 10.2 million, if the total assets are less than 5.1 million, and also if the number of employees is less than 50. Could I get the next slide, please? So once you've got the sponsorship license and it's been approved, then you have reporting duties that you need to comply with, as well as record keeping duties. In terms of the record keeping duties, specific events need to be reported to the Home Office using the sponsorship management system. And this is done by the level 1 user. So the kind of things that you would need to report is, say, for example, the employee did not turn up to work for their first day of work, or if they haven't been working for 10 days without you knowing. If their details change, for example, their job title, role, or salary changes. So you need to normally report those within 10 working days. There's also a requirement, excuse me, for certain things to be reported within 20 working days. For example, if there is a change in the ownership of the business, or there's different branches that are going to be added to the business, or if there's a merger or takeover. In terms of record keeping duties, it's more to do with documentation that you need to keep on file for each individual person. So, for example, passport copies, biometric cards, employer checking service documents, just to make sure that people that are being sponsored by you have the right to work. And so if the Home Office representative does come and audit you, you can show them the trail. In addition to that, you also have, need to comply with the UK laws in terms of paying the individual migrants the relevant salaries, and also, paid with the time regulations and paid holiday entitlements, and any other relevant legislation such as the Data Protection Act 2018 needs to be complied with. Could I get the next slide, please? Thanks. What I've done here is just provided an example, a working example of the legal duties for sponsors, and I've done this in a case study form. So if, for example, company A wanted to sponsor somebody who's a US national, and they obtained the visa for her for 5 years to work in the category of market research analyst, that comes under a code of 3543, which is in the immigration rules and on the Home Office website. If the employee in this example performed really well at her job, and she was promoted 2.5 years later to a market research manager. Now, whilst those roles seem very similar, in the immigration rules, the codes are different for those jobs. And if the Home Office, if the employer didn't inform the Home Office of the change in job title, then there would be a serious breach of the sponsorship license rules and regulations, because when the person's been promoted to market research manager, the salary that she needs to be paid is around about 30,000, so it's £38,200, whereas under the market research analyst stock code, the salary is 24,400. So if that wasn't inputted onto the sponsorship management system, that she's changed her job title, that would be a major breach. Also, because it's changing from one stock code to another, actually a new application would need to be submitted for a certificate of sponsorship and potentially a new visa application as well. Could I get the next slide, please? Thank you. The next section that I'm going to come on to is the visa eligibility and what is a certificate of sponsorship. So could I get the next slide? And the next one. Thank you. So here we've got, as I mentioned earlier, you have like a stock code. So on the Home Office website and in the immigration rules, there's lots of different stock codes depending on what category of job you may want somebody to be employed under. So I've just listed a few here. So stock code 2317 is in relation to senior professionals or educational establishments. Code 2423 is in relation to management consultants and business analysts. And code 2436 is in terms of construction, project managers and related professionals in that area. Now, with these particular stock codes, there is also in the immigration rules the type of salary that you need to be paying these individuals, and you must comply with that and the salaries that are in the immigration rules are based on a 39-hour week. So if the foreign national is going to be employed for less than 39 hours or more than 39 hours, it would need to be prorated. In terms of the salary requirement, as I mentioned, in the immigration rules, it's mentioned what the salary would need to be depending on what code it is. But if the job is on the shortage occupations list, then the salary requirements are less, or if there is a new entrant, or if it's a relevant PhD type position. Could I get the next slide, please? So on the shortage occupations list at the moment, the major ones are care workers and home carers. And they've been on the shortage occupation since 2022. The Migration Advisory Committee have recommended a number of job titles in the construction industry to be added to the shortage list, such as bricklayers, masons, roofers, roof tilers and carpenters, and hopefully they will be added by the summer of this year. There is also talk with the MAC, the Migration Advisory Committee, that some roles in the hospitality industry also be added on the shortage occupations list, but that hasn't been confirmed as yet, as the Migration Advisory Committee has asked for more information from the hospitality industry in terms of this. I've just also provided another case study here in terms of if the job is on the shortage occupations list, what the salary would look like. Excuse me, in terms of that. So, for example, if a company B wants to employ a web designer, the occupation code is 2137. And normally the company would have to agree to pay the worker an annual salary of £26,000 at a 39-hour week for the worker. However, as this job, as I mentioned, is on the shortage occupations list, the annual salary can be reduced by 20%. So that would make it that it needs to be paid £20,800 per annum. So there is quite a significant saving in terms of that. Could I get the next slide, please? So here I'm talking about the certificates of sponsorship, and with the certificates of sponsorship, there's two different types, and there's defined and undefined certificates. So defined certificates are for those people who are currently outside of the UK and are wanting to come in to the UK to carry out a specific job for a particular employer. And with a defined cause, it's an application that you need to make on the sponsorship management system once you found the right person for the job. You then put all their details into the sponsorship management system, including their salaries, their personal details, and within 24 hours, a certificate should be granted. With the undefined certificates of sponsorship, you have an annual allocation of these certificates. And so if somebody is already in the UK, either in the UK on a skilled worker visa working for a different company, or perhaps they're a dependent of somebody and they want to switch to a skilled worker, you would use your annual allocation to to assign a certificate to them. To assign the certificate to the individual, the government fee is £199. And in addition to that, you need to pay what's called an immigration skills charge. If the company is classed as a small or charitable company, then the immigration skills charge is £364 a year. If they're classed as a medium to large sponsor, it's £1,000 per year. Normally, people are given, or you apply for a visa for 3 years. So in the example of a medium to large sponsor, the immigration skills charge would be £3,000. Could I get the next slide, please? There are certain jobs that don't require you to pay the immigration skills charge, and I've listed them here. And this list is correct as of Monday this week. So that includes chemical scientists, biological scientists, other ones in terms of higher education teaching professions, clergies, sports players, sports coaches, instructors or officials. Also, what I should mention is with the immigration skills charge, even though it is, for example, a lot of money, if the skilled worker is working for you, if, for example, they're working for a large company, and as I mentioned, the immigration skills charge would be £3,000. If they leave the job, let's say, for example, after a year, and that's then reported on the sponsorship management system within 10 working days of them leaving, then within 90 days of that, you as the organisation should be refunded the £2,000 left that you'd paid in advance. Could I get the next slide, please? I'm just going to come on to now the visa application and the government fees associated with that. The next slide, please. Thank you. So in terms of this, you have supporting documents, and in terms of that, what kind of documents are they? It will be confirmation of the English language test. So if the person is from the US or Canada or Australia, for example, they don't need to show that they can speak English to the relevant requirement because it's assumed that they can already. So all you would need to be showing is their passport to support that requirement. But if, say, for example, they're from India, Pakistan, or other such countries, then either they would need to show that they've got a degree that was taught in English and that be confirmed through an organisation called ECTIS, or they can complete an English language test, and there's specific test centres that can be used in order to make sure that they meet the requirements for the English language. Also, depending on which country they are from or which country they've been residing in, they may need to take a TB test, and also you may need to have a criminal record certificate from the country that they're applying from and other countries that they've resided in for the last 10 years. So that's more in relation to the medical profession or teaching profession. So once you've got the relevant documents, the online application form needs to be completed and the government fees also paid. So if you're making the application inside the UK and you're applying for a 3-year visa or less, the government fees is £719. And if you're applying for over 3 years inside the UK, it's £1,423. And I've also provided what the fees would be. If you're outside of the UK, it'd be £625 and £1,235 if it's for over 3 years. You also have what's called the immigration health surcharge that needs to be paid, and this basically is £624 per year. So if you're applying for a 5-year visa for an applicant, the government fees in total would amount to £3,120. So once all the fees have been paid, the individual would need to attend a biometric appointment at a relevant visa centre close to where they are, or if they're in the UK, depending on which city they're in, there's biometric centres all over the UK as well. If they are European nationals who are applying, they can normally use a Home Office app to scan all their identity documents, and they don't need to actually attend physically a biometric centre. The processing times for visa applications, if you're just using the standard service, is normally around 8 weeks, but there is priority services and super priority services in which super priority you get a decision within 24 hours and the priority service is normally within 5 working days. Could I get the next slide, please? They're just the fees. Yeah, the next slide, please. And that's just the immigration health surcharge. Yeah, and so on this one here, I've just outlined in terms of government costs, the minimum and maximum cost that it would be depending on the size of organisation. So the first one, if they're applying for 3 years of sponsorship, the minimum government fees would be £3,788 and the maximum would be £5,719 total. And then once they've had the visa for 3 years, they would need to apply for an extension of 2 years. And the minimum government fees associated with that application would be £2,894 and the maximum would be £4,166. So in total, the minimum government fees would be £6,682 and the maximum would be £9,956. Now, excuse me, as I'd mentioned, the immigration skills charge, which is probably the most expensive government fee, if the employee leaves, that can be you can get that money back, or well, part of the money back in terms of that. Other government fees in terms of the visa application fee, the immigration health surcharge fee, they can all be paid by the individual. They don't have to be paid by the employer. So it could be that you have a situation where if the employer's salary is above X amount, that you as a business decide to pay for their government fee, all of the government fees. But if it's below, potentially, you know, from an immigration perspective, you don't have to. You could have a thing in the contract to say that you're not going to be paying all of the fees, or you could also have a clawback clause in their contract to say if they leave after, you know, within 12 months, they'd have to pay 100% of the fees back, and if then year 2, year 3 have a sliding scale, so it's less that they would have to pay back should they leave. So it's just putting things in place to prevent you as an organisation losing money if the person leaves the business. Could I get the next slide, please? In terms of the benefits of sponsoring, I mentioned that, you know, it can be seen that it is quite expensive in relation to government fees in employing skilled workers, but the cost of employing somebody who's not the right person for the job and you've only employed them really because you haven't got a sponsorship license, could be that you've employed the wrong person, and in the long run it's going to cost you more money. In terms of helping you with the process, we can definitely help with streamlining the process to try and reduce costs as much as possible and put forward what costs can be passed on to the prospective employee. Also, when people are sponsored, they are more likely to kind of remain within your business because they do find it more difficult to find sponsorship. So by you employing somebody, they are having to stay, well, they're going to have to be employed by you full time because they can't, unless they have another sponsor, they won't be able to move from one sponsor to another. And at the moment, we can see that some companies are still reluctant to apply for sponsorship licenses for their prospective employees or new employees. Could I get the next slide, please? Thank you. So as I mentioned, if you just, yeah, thank you. As I mentioned, there are obviously fees associated with government applications, but visa applications, immigration health surcharges, and any priority fees can be passed on to the employee. The only things that can't be are the fees for assigning a certificate of sponsorship and the immigration skills charge. But as I've mentioned, the immigration skills charge, you can recoup that back from the Home Office if the person leaves before their visa has ended. Also, when somebody's in the UK on a skilled worker visa, not many people realise that they can work, in addition to their skilled worker employment, they can work 20 hours of supplementary work outside of their normal working hours, but it needs to be in the same SOC code. So for example, if I, as a lawyer, are sponsored by Owen Mitchell, I could potentially work 20 hours as a lawyer for a different firm without getting sponsorship. So if I was looking to potentially move to a different firm, the other firm may want me to kind of work for them for 20 hours per week, just to see if I am a right fit for their organisation. And if I am, then they may want to sponsor me. So it's a way in which you can potentially test out the person to work for you, to see whether they're going to be a right fit for you. And then if you think that they are, they can then come and work for you for full time once they've applied for the correct skilled worker visa in order for them to do that. Could I get the next slide, please? I'm just going to now go through a quick recap in relation to what we've discussed. Next slide, please. Thank you. So as I mentioned, the first step is for the organisation to get a sponsorship licence. And if you get the sponsorship licence, if it's a small company, the government fees would be 536. And if it's a medium or large company, it'd be 1,476. And in terms of timescales to get the sponsorship licence, once you've submitted all the relevant documents and whatnot, decisions can be made within 8 weeks. But if you use a priority service, it can be within 10 working days. Once you've got the licence, depending on if the person is in the UK or outside of the UK, you would need to assign the certificate of you need to assign the certificate of sponsorship. And then once that's been assigned, the individual would then apply for their visa to then come and work for the company. And the timescales is currently 3 weeks if you're applying using the standard service outside of the UK, and 8 weeks if they're applying for inside. But as I mentioned, there is priority services as well, and with the priority services, excuse me, a decision can be made within 24 hours to 5 working days, depending on the priority or super priority. Could I get the next slide, please? And I'm now just going to quickly touch on the right to work checks. Thank you. So here I've just done a diagram in relation to the right to work checks. So if you've got to consider, is the worker a British or Irish national? If they are, then you can use the IDSP digital checks to make sure that you are compliant. If they're not British or Irish, the next question is the worker waiting for a decision on an application, an administrative review or appeal? If they are, then the way in which you would carry out the check would be using the employment checking service link on the Home Office website. If they're not waiting for a decision, then you can use the Home Office online service, or otherwise you can carry out a manual check in terms of you look at their passport, you look at them, that they've attended your office, and you write on the documentation that you've seen this person is the person on what day you saw them, and then you would keep a secure copy of that document on their HR file. Could I get the next slide, please? So just the things to note, really, and what's coming up. Biometric residence permits, like the BRP cards, are not going to be issued beyond 31st of December 2024. So even though somebody might apply for a 3-year visa, so the visa should expire in 2026, the biometric card will only go up to 2024, 31st of December. And that would mean that on or slightly before the 31st of December, you'd need to carry out right to work checks for those people, just to make sure that they still have the right to remain in the UK, which they will, but it's just to make sure that you've got the paperwork to support that, or online paperwork, should I say. Also, from the 1st of January 2025, the only way people are going to be able to prove their immigration status is online. There's nothing really to panic about. It's being phased in slowly, so hopefully you as organisations should be seeing that it has been possible to do, and it's not so difficult once you get your head around it. And it's just important to diarise dates. So I would diarise the 31st of December 2024 in terms of the biometric card, and then you can move on to the online checking system. So that's the presentation I'm done with. I just had a couple of questions in terms of, in your experience, if you as an organisation do sponsor migrants, and if you don't, are you avoiding, why do companies avoid sponsoring migrant workers? So that's just a question to everyone. Another question is, what are the biggest concerns companies have when sponsoring workers? And you can put that in the Q&As if you want your answers in relation to that. And also, at what points of the sponsorship process is advice most helpful? So I'm just checking. Okay, and that's all I have got to say. If there's any questions.
Mandeep.
Yeah.
Thank you for that. That was really helpful. There is one question in the Q&A box, and it came up on one of the pre-submitted questions as well, and that's in relation to spousal visas, and what employers can do to prove that they're still eligible for one in the event that that relationship has broken down.
Yeah, I mean, what you can do, I mean, as an employer, all you can do is maybe every so often send an email or have a meeting with the individual to say, you know, you're currently on a spouse visa. Are you and your partner still together and in a subsisting relationship? And if they say yes, that kind of covers you as an employer. If you feel it should be noted with a spouse visa, if somebody's in the UK on a spouse visa and they're having a temporary separation, so one party has moved out, that doesn't necessarily mean that they need to be moved to a skilled worker visa, because, you know, it might be just like a trial separation. But if that is brought to your attention, you'd need to monitor that carefully, because if it is that it becomes more permanent, then that would need to be reported, and then that would be at that stage you'd need to apply potentially for a skilled worker visa if you wanted that person to still be employed by the organisation.
Okay, that's great. The other questions related to the slide deck. Yes, of course there was a lot of information on those slides, and really useful information in terms of the process on the application and the fees attributable and etc. So what we can do is we can send those slides out as part of our follow-up at the end of the session. And yes, there'll also be a recording as well. I'm just going to look at some of the pre-submitted questions as well. Now, there was some talk about getting sponsorship, which I know you've already covered, in the Tier 2 visa process, but my understanding is that it's no longer called the Tier 2 process anymore. Isn't that correct?
Yes, it's a skilled worker visa. It's exactly the same thing, but it's just called the skilled worker route now.
Great. There was a question about related costs of sponsorship license and sponsoring a candidate. Is there any related costs that you can think of over and above the Home Office fees?
I mean, our fees, legal fees, if it is that you wanted assistance with, you know, either preparing the sponsorship license. So, for example, our fees to help with a sponsorship license for a standard one range between £3,500 to £5,500, depending on which routes you want to apply for. So if it's just the skilled worker route, or if you're going to be adding more additional routes onto it, then yeah, our fees would increase to the higher end of that fee quote. And then also helping with the skilled worker visas, our fees would be around about £2,500 to £3,500. But again, legal fees in terms of the visa application, they can be passed on to the employee if you wish. And again, you could do the clawback clause in relation to legal fees as well.
That's great, thank you. I don't think there were any other questions that came up this morning. I'll wait and see if there are any further questions added in the Q&A box. But this is just a reminder for everyone that Jessica has put the link to the feedback form in the Q&A box. So if you do think of any questions after the session this morning, then please do let us know, and we'll come back to you with our answers to those. Or if you need any more information on immigration process generally or employment law, then you know where we are, and we're happy to help.
That's great, thank you.
Thank you. So I think on that basis, we'll give you all 10 minutes back. But thank you very much for joining our webinar today, and thank you to Michael Page as well for partnering with us again on this event. We'll see you all soon.
Thanks. Bye.